Hello, and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. As many of you know, it has always been difficult to win in immigration court, and it is more difficult now since Trump essentially has given the green light for anyone and everyone to deny whatever they can, even though many times the basis for denial is either unlawful, not accurate, or is simply an abuse of discretion. So the reality is that sometimes you have to fight a few battles in order to win the war, and that is more apt today than it has ever been. So procedurally speaking, what you want to do, if you have to do this, is you have to get through the administrative part of immigration before you get to the judiciary. So what does that mean? So let's just say you get served with the notice to appear, and you end up in immigration court. Now, that's by itself going to take a long time. So a couple, 3, maybe 4 years later, you finish with immigration court, and let's say for whatever you applied for, you get a denial. So you get a denial that gives you 30 days to appeal to the BIA, which is the Board of Immigration Appeals. That also is under the ambit of administrative processing. You still have not reached the judiciary, meaning, basically real federal judges who have been appointed by the President of the United States and confirmed by the Senate, and they hear all kinds of cases, not just immigration. So, in that regard, you get it to the BIA in sufficient time. There's an automatic stay of deportation. And, there's other things you have to request, but that takes more or less 1 to 2 years. Okay. And now let's say we're at the end of the processing time and you get a denial from the BIA. Well, this is now the first time that you can actually get your case to be heard in front of federal judges that, for the most part, will give a fairer hearing, will listen to the evidence more closely, will not boilerplate an answer or denial, and will allow you to really fight your case. So this is known as a petition for review. So it depends what area of the country you're in, because if, for example, if you look at the Supreme Court of the United States and then draw, lines underneath it, okay, for example, around 12 lines underneath it, and then put a little court at the end of each one of those 12 lines, that basically represents the entire United States Circuit Courts of Appeal. Now, the circuit courts of appeal handle basically a slice of the United States. So, for example, if you're talking, around California, Oregon, Washington, Hawaii, Nevada, Arizona, those are all in the Ninth Circuit. Okay, if you're talking Texas and around that area, Fifth Circuit. If you're talking Florida, around that area, it's 11th Circuit. If you're talking Washington, D.C., it's the D.C. Circuit. So, you need to, of course, do a petition for review to the proper jurisdiction. But once you get the petition for review, you also do an emergency motion to stay the deportation, because doing a petition for review does not automatically stay the deportation. And then what happens is it ultimately goes in front of 3 judges in that circuit court, and they may or may not allow or request oral argument. They may or may not summarily dismiss the case. They may or may not rule on the case without any oral argument. So, obviously you still have to do a good petition for review to have it heard, because if they, the bottom line, if they look at what you filed and it's garbage, they're just going to summarily dismiss it, and the case is gone, and that's going to be a final order. And, you could go and do what's called a petition for review en banc to all of the justices, but the chances of them hearing that are really small. And you could do a writ of certiorari to the U.S. Supreme Court, but again, if you just filed a petition for review that doesn't have meritorious arguments at all, it's never going to get to the U.S. Supreme Court. So you need to make sure it's done right. But the bottom line is it's going to go in front of three justices. They are then going to decide the fate of your case. Now, you have to understand they're not under the rules that have been promulgated, for example, by the Attorney General in immigration, which essentially says we need to move these cases out quickly. We need to look and see how many cases you've decided. We need to essentially erase due process for all of these people applying and just get an answer out the door, because that's essentially what's happening today. That's not going to happen once you get a petition for review to a circuit court of appeal. They will rule on the merits of the case. And so that's why I'm saying you have to sometimes fight a few battles to get to the win, hopefully, and to get to a real chance. Because you have to understand, a circuit court of appeal, they hear all kinds of stuff that are, federal cases: criminal, immigration, tax, environmental, banking, fraud, all kinds. So they will take this much more seriously, and without the artificial deadlines and the artificial denials that many times will occur in the administrative context. So there's always hope. So if you like the video, click like, subscribe, and more on the coming weeks. Thank you.